I'm so happy to see you virtually.
Walaikum assalam. How
And
are you?
I'm doing all right. Thank you so much, sir. Today is a remarkable day. This is our 10th, like the roundtable talk. We have been organizing that for almost 2 years. As we have already
Uh-huh.
talked like the last week, we decided to do it like the monthly for the academicians, and for the following like the weeks, we will be doing organizing another roundtable talk for or only for students. We are very excited to see that. And I would like to give the stage to the or dean. And yes ma'am. Sayın Dekanım buyurun lütfen.
Good afternoon to everyone. Distinguished colleagues, esteemed guests and participants. It is a true honor to welcome to you this special session of the Roundtable Talks. We were gathered to explore contemporary perspective on law. This event marks a significant moment of collaboration between Ankara Yıldırım Beyazıt University Faculty of Law and Tashkent State University of Law. In a world where legal challenges evolve rapidly and our societies confront unprecedented transformation, this platform represents our commitment to fostering dialogue and sharing knowledge across borders. In recent years, the legal fight has witnessed profound changes, many driven by advancement in technology, shift in societal expectation, and the growing complexity of international relations. Today, we are here to address these changes head-on. Our topics will range from the impact of artificial intelligence in legal decision-making and ethical consolidation surrounding AI, to the adaptation of practice of digital platform and unique regulatory approaches to emerging technologies like cryptocurrency in Uzbekistan. These discussions are timely and critical. The legal fight, while often rooted in tradition, must be adaptive and responsive. As educators, researchers, and practitioners, we have a duty to ensure that our legal system evolve in a manner that upholds justice, fairness, and human dignity. Events like these are vital in keeping in progress as they bring together dire insight, foster constructive debate, and encourage innovative thinking. I would like to extend my sincere gratitude to all esteemed speakers who bring with them a wealth of expertise and experience, and to all colleagues at Tashkent State University of Law, especially Professor Dr. Sayed Gulyamov for his unwavering support in making this collaboration possible. I am also particularly grateful to Assistant Professor Dr. Samet Tatar, who will be moderating today's session. His work in cyber law continues to inspire many, and his insight will undoubtedly reach our discussion. To all participants, I encourage each of you to actively engage today's discussion, ask questions, and share your perspective. Your insights are what make this event dynamic and valuable, and together we can pave the way for a more adaptable and resilient legal framework in our respective country and beyond. Thank you once again for joining us. Let's us make today a memorable and impactful exchange of ideas. I look forward to thoughtful dialogue dialogue that will shape the future of our legal landscape. Wishing everyone a successful event. Thank you very much.
Thank you so much, Professor. We truly appreciate your nice opening speech, and I would like to give this stage to the Professor Guglielmo, who is actually the founder and then the architect of the whole the academic partnership between Ankara Yıldırım Beyazıt University and Tashkent State University of Law. And I truly appreciate his mentorship and his leadership for our the sustainable long-term the collaboration between two distinguished institutions. Professor Gulyamov, your turn.
Thank you very much. Samet, you are one of the best moderators which I know.
Thank you.
Assalamu alaikum. Professor Neslihan Karatash Durmush Hanum, esteemed colleagues from Ankara Yıldırım Beyazıt University and participants, especially for you, Samet Tatar. How are you? It's my great pleasure to welcome you to this roundtable discussion on the digitalization and cyber law, and collaboration with our institutions that highlights the growing importance of international dialogue in our digital governance. Uzbekistan, like Turkey, after reaching real independence with our new president, His Excellency Shavkat Mirziyoyev, is experiencing a dramatical digital transformation. Our government has embarked on an ambitious Digital Uzbekistan 2030 strategy, which aims to modernize our economy and public services through the digital technologies. This transformation brings to the forefront of crucial legal questions about the data protection, cybersecurity, digital rights, and regulatory frameworks in all spheres. The collaboration between Tashkent State University of Law and Ankara Yıldırım Beyazıt University represents more than just academic cooperation. It symbolizes our shared commitment to addressing these challenges through the international dialogue and the knowledge exchange. Our Turkic countries share not only historical and cultural bonds, but also common aspirations in the digital age. Legal education must be involved to meet these new challenges. At Tashkent State University of Law, we are actively developing our curriculum to prepare the next generation for the legal professionals for the digital future. And I am particularly interested in learning from our Turkish colleagues about your experience and approaches in this domain. You are a more developed country than Uzbekistan, but I hope in the nearest 10-15 years, we will reach your achievements soon. And I think this adopted European laws, which you are using right now in Turkey, we can straightly adopt, because it's already you made it your legislation upgraded and made it useful for Turkey, for Muslim country. And for us, for Uzbekistan, it's a very great opportunity to learn from Turkey and upgrade our legislation, because our legislation is still living in the Soviet Union legislation, this Russian, former Soviet Union legislation, which we need to live from that legal system, and we have to remove our legal system to this Turkish style and that's why we need the big experience of the Turkish academic scientific peoples to help Uzbekistan to upgrade our legislation. And today's roundtable provides an invaluable opportunity to share perspectives, exchange ideas, and strong academic ties between our institutions. Let us use this platform to build a bridge between our legal traditions and work together toward the developing effective legal framework for our digital future. And thank you very much for your attention. And I hope this platform, which you are starting again, Samet, Thank you very much again for your initiatives. We will start, and I hope we will reach a big achievements in this field, and we can do the highly exchange programs with our universities. And tomorrow we can leave the digital legacy in our country's legislation. Thank you very much.
Thank you so much, Professor Guglielmo. I am wordless because you have already given like more than like the great speech. That's important. Like the Professor Guglielmo was actually highlighting the importance of the Turkish experience relating to harmonizing like its own legislation with the EU directives. Turkey has been working on it for years. And we are also very dedicated to support the Yeni Uzbekistan, the new Uzbekistan's legislative, like the legal reform process. And inshallah, from time to time, we may be organizing like the special events relating to the lawmaking process of the like the Yeni, like the new Uzbekistan's like the strategies. And today we do have like the five like the panelists. Our first panelist is Professor Cheleng. She has been already in Uzbekistan like the recently, almost like a month ago. She is head of or like the private international like the law department. Professor Guglielmo used to be the head of the Tashkent State University's like the private international law departments as well. Professor Cheleng holds a PhD from like the Switzerland, a very prestigious, distinguished university. She's fluent in English and in German. Today, she's gonna talk about the online, like the hearings, like the relating to the Turkish experience from the Turkish courts. Professor Cheleng, you do have 15 minutes. That's your turn. The stage is all yours. Thank you.
Thank you very much. I'm going to share my material. I hope I will, great. Sorry for.
We can see your desktop right now.
Desktop, yes.
Right.
Oh, okay, great. On the desktop, YouTube connection or something like that. Sorry for this inconvenient. And thank you very much for organizing this great event. It's our pleasure to take part in the 10th one. I'm very pleasure to be part of once again, and who had effort. I know Dr. Samet intensively supported these events, and other all participants and contributors to this event. I would like to thank you once again. Today, I'm going to talk about the online hearings in Turkish civil courts practice. It is very recent topic, actually. Where the technology and justice intersecting together nowadays, and I thought maybe the online hearings can be one of best topics for this interaction, to show this interaction. And this is my roadmap for today. I'm going to mention about this Turkish National Judicial Informatics System. In Turkish is known as UYAP, and legal basis for online hearings in Turkish civil procedural law. Of course, there are some advantages, apparent advantages arising from holding online hearings. On the other hand, there might be some disadvantages I'll be very briefly mentioning. And I'm going to finally mention the rejection grounds and how online hearings can be applied. Once again, at the introduction, I mentioned technology and justice is together when we are talking on the online hearings, because technology is promoting here justice from some way. And at the same time, UYAP, this is National Judicial Informatics System, is a platform for facilitation of administration of justice. So before handling online hearings, we should mention what is Turkish National Judicial Informatics System first. This is a system connecting online by connecting the courts to each other By doing that, it's reducing expenses of bureaucracy, and of course, the postal costs are reduced. And on this platform, we have lawyer platform, expert portal, mediator portal, citizen portal, and there are some mobile applications like Jelse for lawyers, for any kind of facilitation to access is actually developed and trying to be developed day by day for all actors of the administrator of justice, day by day being improved. And also through UYA, once again, this national portal for court administration, and the lawyers may file their cases, they might commence their cases on UYA. They can submit petitions and evidences to the court. They follow up case files, and through some links between these banks and this system, the lawyers can pay some cost, actually some procedural cost, or they might deposit court expenses electronically, which is also facilitating their daily usage in this sense. And online hearings combined to this system, and with this combination, the online hearings application providing lawyers without being physically in court, before the court, they can attend some sort of hearings before civil courts. I'm going to be giving some details about this. This online hearing, the matter of online hearings was initiated in September 2020, and it was COVID pandemic time, and it accelerated the implementation of online hearings before civil courts. And today, online hearings applicable in 81 provinces, which means that all Turkish provinces, I mean, all from east to west, all cities, courts, civil courts, accessible through online hearings, which is a great number, and I'm going to give a huge number, more than 1 million online hearings already held on this platform. So if you're interested in details, this is the website of Minister of Justice. You can check out the source I give here for some numbers. And the legal basis is Article 149 of Turkish Civil Code. And according to the court may decide to conduct remote hearings through video or audio transmission upon the request of one of the parties, or ex officio under circumstances, And the details, I mean, the procedures and principles regarding the implementation of this article is left to the regulation. And now we have a regulation related to the execution of the hearing by transferring audio and video in civil proceedings. It's also entered into force on 30 June 2021. And this regulation reminding that certain principles must be considered while holding these online hearings before the courts, which one is publicity, procedural economy, the obligation to act honestly and tell the truth, the right to be heard legally, the judge's duty to clarify the case, the principles related to conduct and administration of the proceedings shall be taken into account while implementing these hearings in an online way. In addition to those principles, the information security must be ensured. The personal data matters must be considered, and personal data must be protected. Service quality and the national and international standards must be ensured and complied with those standards. And I'm very fast shifting to advantages because I have under pressure of time at the moment. Of course, the main important advantage is cost efficiency and time effectiveness. From west part to east part, from in Turkey, if as a lawyer you have to drive for your one trial, maybe you need to drive almost 20 hours. But if you have an online hearings, you don't have to drive such a way. And this is cost effective, not only for your budget, but also for your time. So the most and apparent advantages at the moment seem as cost and time effectiveness. On the other side, since we are talking technology, always there are some surprises in technical matters. So some technical issues and connection problems during the hearings can be some problems, and this is shown as at the moment as one of disadvantages. And the application part only possible for lawyers at the moment with electronic signature, which is a specific signature, and through UYAP system, once again, Judicial Informatics system, lawyers can apply through lawyer portal, and also the application, the JLSE, the hearing in English also, through this application. This request can be sent to court 24 hours before the relevant hearing at the latest. At the latest, you have 24 hours to apply for online hearings. And how about the rejection? The rejection, the request is not made within the split. If the request is not made in a proper time, this can be rejected. And if court understand that the intent, there is an intent of abusing the rights, or there is an intent to cause a delay in the proceedings, then the court might reject this request. Or there might be some legal, factual, or other technical obstacles, still court might reject based on these obstacles. But as far as I know, I heard from the practitioners, the Turkish practice mostly, the rejection of Turkish practice currently based on technical obstacles, and some cases not allowed by online hearings, like if a statement of waiver, acceptance, or settlement of a case of a dispute is at concern, then online hearings, doing this settlement, acceptance, or waiver is not possible at the online hearing. According to court, this is arising from the signature matters. So it's not possible to do that online hearings based on problems of signature. Maybe in near future it's also coped with, and but now it's not accepted to do that. And maybe in your minds, the documentation of the online hearings can bear, and the official evidence of the hearing is the hearing transcript. This hearing is being transcribed at during the online hearing, and this is being shared on the lawyer's screen during the hearing, and the court doesn't accept holding a preliminary examination hearing in matters requiring the lawyer's signature on transcript. Once again, I mentioned at the previous slide, because this is still considered a technical issue. If lawyer's signature is required, then currently the court is not accepting this.
Professor Çelenk, you got 3 minutes left.
Great. I will be down in 3 minutes. This is screen what the lawyers can see on UYAP. And here you can see this red button. If you click on red button, then you will be in the courtroom. So here is the courtroom, and as a lawyer, you will be here in front of the judge and the clerk. So this view is from courtroom, and this is my my last slide. And how about the restrictions? And there were some restrictions, like you can't take photos during online hearing, and or you cannot have video recording during the online hearing. If you act so, if you violate these rules, then there are some criminal sanctions under Turkish Penal Code against this acts. But still, there can be some cases. There can be some mandatory situations. The courts may decide to record the proceedings, to record the online hearings. But please remember, currently the documentation is only the document, written down during the online hearing. Not all online hearings are recorded, but if it requires so, courts may decide to get recorded the hearings. And thank you very much for your attention. Just for final remark, 2 weeks ago, I was in Tashkent. I had great time. Thank you very much once again for the warm hospitality you showed us. It is once again great to be together. Thank you very much for all. Thank you very much.
Professor Çelenk, thank you so much. She was actually an Erasmus, visiting the fellow, going to the Tashkent for a week to teach some courses while doing some legal research and meeting with the administrative persons of the university. Here, we truly appreciate your presentation, insightful presentation on the online hearing experience in the Turkish court system. As you have already mentioned, that the innovative use of digital platform surely has been already improved the accessibility and then efficiency within the judicial process. Your expertise has provided valuable perspective on how technology continues to transform legal proceedings in Turkey. And do you guys have any questions, comments relating to the Professor Çelenk's presentations? Do we have any questions from our YouTube channels, friends? Okay, thank you. Right now, we are gonna listen to the Professor Bihter Kaytaz Eker's the presentation. Professor Eker holds an LLM, a PhD degree from the UK. She specialized in international arbitration law. She's an academic person working at private international law department at Ankara Yıldırım Beyazıt University of Law. And today she's gonna talk about the AIs, whether or not AI can be replaced as a human arbitrator in the task of making decision makings. And ma'am, you got 15 minutes.
Okay,
the stage is all yours.
Thank you so much. Good afternoon. The title I have chosen for the presentation here today is Artificial Intelligence is Everywhere. Can AI replace human arbitrators in the task of decision-making process? While Dr. Samet Tatar introducing myself, he shared my interest in studying on commercial arbitration. So the topic for this presentation would for sure relate to this particular area. And in the face of that, artificial intelligence-based technologies is certainly making strides in various fields, including arbitration. I decided to question whether it can fully replace human arbitrators or not. And it is a nuanced question indeed. And this presentation will particularly focus on the increasing role and impact of artificial intelligence. And there will be an attempt at the end to question whether AI can replace human arbitrators or not. While focusing on this particular question, my role in this presentation will be first to understand what the artificial intelligence and arbitration is. Then I will focus on the current status of artificial intelligence in arbitration. Following this, I will attract your attention to limitations of the current regulatory framework regarding replacement of human arbitrators with AI arbitrators. Finally, I will mention about one recent guidelines for the use of artificial intelligence in arbitration. Let's start from the basic. What is arbitration and artificial intelligence means? Indeed, there has not been an official consensus on the definition of artificial intelligence yet. This results from because artificial intelligence is an umbrella term which covers various subjects and techniques such as machine learning, neural networks, and natural language processing, etc. For the purpose of this presentation, the term artificial intelligence refers to not only to computer systems that provide simple answers to questions or make predictions about possible decisions, but also complex self-learning systems which collect and analyze data and reach decisions without human intervention. And AI is used in various fields from healthcare and finance to entertainment and transportation, as significantly impacting how we live and how we work. And arbitration is one of these fields that AI has started to be very active. And before talking about its current status in the field of arbitration, let's define the arbitration briefly. In today's global economy, business relationships are established and maintained on an international scale. And when parties in such relationships find themselves in disagreement, international arbitration exists as an option to resolve their disputes. And there are many advantages to pursuing international arbitration as a resolution mechanism, such as enforceability, neutrality, confidentiality, and more. When it comes to the current status of artificial intelligence in arbitration, we may notice a very attractive assisting body role of artificial intelligence in terms of not only the parties or their counsel, but also the arbitrator and the arbitral tribunal. First of all, AI systems assist in foreseeability of the arbitration process and legal certainty to some extent. What I mean by saying foreseeability, or let's say predictability of arbitration process and legal certainty, indeed, it covers the predictability of the chance of success, the amount of possible compensation to be awarded, the duration of the arbitral proceedings, of course, depending on the arbitral institution, and cost, as well as the outcome of the case. It is certain that such predictability depends on the existence of a reliable data pool of previous arbitral awards, which includes the elements of disputes that are subject to arbitration, the rules governing the arbitral proceedings, and any previous awards rendered according to these factors. However, unlike court proceedings, international arbitration is a private dispute resolution mechanism where the submissions of the parties, the arbitral hearings, and the arbitral awards remain confidential. And arbitral institutions usually don't publish the arbitral awards. Considering all these information, non-publication of arbitral awards or limited amount of data obtained in international commercial disputes may raise as a barrier of the use of AI technologies in arbitration because data plays a very central role in their development. And nevertheless, today there are databases that are in use for providing data in arbitral proceedings, thereby providing predictability for parties and their counsels in arbitration, such as arbitrator intelligence, dispute resolution data, and global arbitration review arbitrator research tool. In addition to all these, there are programs that provide predictability in arbitration by predicting future results, and Abilex, Revelo, Solomanic are some that we may not hear. Furthermore, artificial intelligence assists the parties or their counsel in the drafting of an arbitration agreement, and it has also been active in most aspects of the main roles of counsel in the arbitration process. For instance, drafting an arbitration clause or an arbitration agreement is one of main roles of counsel in arbitration. And today there are systems not only making analysis on arbitration clauses and make suggestions to improve them, but also drafting an arbitration clause. For example, Kira systems, Clause Builder are some of examples of this assisting by the role of AI today. The other role for counsels in arbitration is to prepare the appropriate documents and petitions by investigating the legal rules and the legal practices related to these facts. And we see software that are able to conduct activities like legal research, creating documents and preparing summaries, all of which purpose to improve the way the counsel is preparing documents and petitions. And one important example of these technologies is an artificial intelligence system that is called Ross Intelligence of IBM's Watson. Another role for counsels in arbitration is to prove their claims that are built in favor of their clients by various evidence methods, including cross-examination. Despite the cross-examination method, which is frequently used in international commercial arbitration and carried out by human attorneys by using psychological methods, has not yet been carried out by any software yet. There are studies showing that AI may be successful in cross-examination. For example, in a study, AI systems correctly determined at a 90% accuracy whether the witnesses who gave testimonies in a hypothetical course are lying or not. Besides all these assisting roles, AI technologies may also assist human arbitrators in various ways, including research and summarizing the relevant law in general, processing and analyzing party statements, or for the arrangement of hearings and conferences in arbitral process. And one example here is the launch of e-arbitration services administered by the Hong Kong's electronic business-related arbitration and mediation platform. So by now we have seen that artificial intelligence technologies are in the use on the resolution of disputes through arbitration based on assistance to arbitral process. And I guess we all agree the benefits of the assistance of such technologies to arbitral process, including speed, cost, efficiency, both for the parties and their counsel, as well as for the arbitrators. However, the increase in the use of AI-based technologies in the field of arbitration brings a very, very big question to our mind, whether AI arbitrators can replace human arbitrators or not. So let's see the legislative limitations in this field. Party autonomy is one of the important principles of international commercial arbitration, and it gives the parties the opportunity to make a choice on different aspects of the arbitral procedure within the limits of the mandatory provisions of the Lex Arbitri, including the choice of arbitrators. Then the parties can select the arbitrators to see their dispute depending on their expertise and abilities. However, there are certain national legislations which explicitly requires arbitrators to be natural persons, such as Turkish Act on International Arbitration or Scottish arbitration rules. When we look at the New York Convention, which is the most significant instrument regarding the recognition and enforcement of foreign arbitral awards, Article 1 states that the term arbitral awards shall include not only awards made by arbitrators appointed for each case. As the New York Convention was drafted at a time, even anyone can hardly imagine the idea of computer. It is silent regarding on whether it covers the recognition and enforcement of the awards that are rendered by AI arbitrators. However, we have seen that provisions of the New York Convention have been interpreted according to the technological recommendation by the UNCITRAL in 2006. Then, in the face of the silence of the New York Convention in this context, there would be no barrier for the interpretation, also covering the recognition and enforcement of awards that are rendered by AI arbitrators under the New York Convention. Even though most national legislation on international commercial arbitration requires the arbitral award to be in writing and to include the signatures of the arbitrators, and the same is required under the convention, we can say this would not be a barrier to cover arbitral awards given by AI arbitrators. This could be dealt with by a predetermined or unique stamp or mark linked to it. So to be more specific, the New York Convention under Article 5 provides for an exhaustive list of limited grounds for the rejection of the recognition and enforcement of foreign arbitral awards, and differentiates between these grounds, who will prove, and the UNCITRAL model law takes a very parallel approach and adopts essentially the same grounds on which an arbitral award may be set aside under its Article 34. Once these grounds are scrutinized, one can easily say that two of them, namely composition of the arbitral tribunal and violation of public policy, deserve a particular attention for the question on whether the human arbitrators can be replaced with AI arbitrators, because they are directly related to arbitrator as the adjudicatory authority. If we start with the composition of the arbitral tribunal, we may say that under the New York Convention, recognition and enforcement of an arbitral award may be rejected if the composition of arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties, or failing such agreement was not in accordance with the law of the country where the arbitration took place. So you may find this provision under Article 5.1d. A similar provision is found under the UNCITRAL model law as a ground for setting aside proceedings. Such provisions may especially be initiated against the arbitral awards given by the arbitral tribunals composed of AI arbitrators if the arbitration agreement between the parties doesn't expressly provide the arbitral tribunal shall be composed of AI arbitrators. However, it is clear that if the arbitration agreement expressly provides for this possibility, then the mentioned provisions should not be applied against the award, either in the setting aside proceedings or in the recognition or enforcement of the arbitral award. Here, there are some more real concerns, particularly in cases where the arbitral tribunal is composed of both AI and human arbitrators. To be more specific, concerns may arise regarding the possible prejudice that human arbitrators may have regarding the inclusion of AI in the decision-making process. Besides, violation of public policy is accepted
Professor
as a
Eker,
ground.
you got 2 minutes left, sorry.
Okay, so the public policy is the other ground, as I noted at the middle of my presentation. From all these, we may reach at a conclusion that the current regulatory framework is not sufficient to defend the replacement of human arbitrators with AI arbitrators. However, it is uncertain whether the relationship between AI and international commercial arbitration would evolve to something else, where there is less human control over the resolution of disputes and AI arbitrators replace human arbitrators. I see this as all depends to the willingness of the parties to include AI systems in the resolution of their dispute by arbitration. As a result, a time may come to amend the current instruments, not the New York Convention, but particularly the ancestral model law, because amendments of the ancestral model law would also affect the amendments of national legislations. And at the end of my presentation, I would like to attract your attention to a very recent guidelines for the use of artificial intelligence in arbitration. It has been published by Silicon Valley Arbitration and Mediation Center to ensure the ethical and effective use of AI in arbitral proceedings. And it was published in 2024 in April. The AI guidelines include several guidelines for all parties, and also for arbitrators. And the guidelines for arbitrators includes the requirement of no delegation of decision-making responsibilities. Then, under these guidelines, the use of AI must not replace the arbitrator's independent analysis of the facts, law, and evidence. Even though these guidelines applies only if the parties agree on it, or when an arbitral tribunal or an arbitral institution decides so. So there's not any study reflecting the rate of its application yet. The mere existence of such guideline that brings a restriction regarding a replacement of human arbitrator with AI arbitrators gives us a clue about the current international atmosphere. I would like to close my presentation by saying that maybe we are going through a period similar to the early 19th century when the use of computers seemed incredible in terms of artificial intelligence. Artificial intelligence usage, and we might be heading towards a future where AI arbitrators are inevitable. So my answer to the question that I raised here today would be not yet, but might be one day. Thank you for listening, and I would be so happy to hear your question if you have any.
Professor Eker, thank you so much for your eye-opening presentation relating to the how we can maybe utilize artificial intelligence as an arbitrator in international commercial or international disputes, and whether or not the AI, whether or not human arbitrators can be replaced by the AI-based arbitrators. Sounds like a very important, a challenging, the questions for not only for practitioners, but also the policymakers as well for the whole legal making process. And she has already talked about the advantages and challenges of the AI arbitrators while digging into the whole legal perspective. Do you guys have any questions, comments to the Professor Eker? She has already mentioned a very recent, the guideline, actually coming from Silicon Valley, where most most big tech companies, the headquarters are already located in. And those guidelines, the details and rules are pretty important because in future, because it could be considered international customary rules, the principle in future, those principles may be adopted into the, you name it, the treaties, treaties, rules as well. Any questions, comments? Okay, thank you so much. And we will have another presentation coming from Tashkent State University of Law. Mr. Islambek Abdulhakimov is gonna talk about the ethical use of AI. When I was in Tashkent, I got the chance to meet him in person. He's a very outstanding, like a promising, like the lecturer working at the cyber law department of Tashkent State University of Law. Sir, you got 15 minutes as well to talk about like the AI use in ethical issues.
Thank you, Professor, for your introduction. It's nice to see you all. Let me start my topic. Honorable professors, esteemed colleagues, and distinguished guests, thank you for the opportunity to speak today on the topic of ethical use of AI. It's a topic that lies at the heart of modern technological and legal discussions. Once again, I will tell that my name is Islambek Abdulhakimov, and as a lecturer in the cyber law department, I am deeply invested in understanding and guiding the responsible deployment of artificial intelligence in our legal systems. Today, I hope to shed light on the ethical the dimensions that must accompany AI's integration into our field. Okay. So, artificial intelligence holds incredible promise in transforming legal practice by automating routine tasks, assisting in complex legal research, and enhancing predictive analytics. AI is revolutionizing the legal landscape. It can help streamline processes, reduce administrative costs, and it can make legal services more accessible to those who need them. However, as with any transformative technology, these benefits are accompanied by challenges that we as legal professionals must address to ensure AI is used responsibly. The promise of AI is undeniable, but we must be vigilant about its potential pitfalls, especially in the legal context where justice, fairness, and accountability are paramount. Let's examine some key ethical challenges. The first one is bias and fairness, as you see in the presentation. AI systems are only as biased as the data they are trained on. Unfortunately, many datasets contain historical biases. For example, in criminal justice, systems that use AI to predict recidivism, biased data can disproportionately impact certain demographic groups. This poses a serious risk in legal contexts where even the perception of bias can undermine the trust. The second is transparency and accountability. Many AI algorithms operate as black boxes, meaning their decision-making processes are not fully transparent. This lack of transparency raises significant ethical questions. How can we hold an algorithm accountable if we don't understand how it arrived at a particular decision? In the legal fields, where every decision can have profound impacts on individuals' lives, transparency is very essential. So the third one is privacy and data protection. AI systems often rely on the vast amount of data, as we know, and including personal and sensitive information. This raises ethical dilemmas around the data privacy. In the field of law, where confidentiality is very essential, ensuring that AI systems respect privacy and data protection laws is crucial. In particular, we must be cautious about how we handle data to avoid any breaches of confidentiality. Let me turn to the next slide. As we discuss ethics, it's important to recognize that some countries and organizations have begun to take steps to regulate AI to mitigate these ethical concerns. For example, the European Union has proposed the AI Act, which aims to create a framework for the responsible use of AI. Closer to home, both Uzbekistan and Turkey, I think, are also grappling with these issues, as they consider how best to regulate AI in a way that protects citizens while fostering innovation. However, regulation alone is not enough. Lawmakers, technologists, and legal practitioners must collaborate to ensure that ethical principles are embedded in AI systems from the outset. Our role as legal professionals is to guide these efforts and ensure that the law keeps pace with technological advancements. As lecturers, lawyers, and lawmakers, we carry the responsibility of ensuring the AI tools are used ethically within our field. We must continually educate ourselves on the capabilities and limitations of AI, advocate for transparency, and demand for accountability. It's crucial that we remain vigilant about the ethical risks associated with AI, and that we advocate for systems that enhance justice rather than compromise it. To navigate the ethical challenge, I have outlined here that we need a set of guiding principles. These are transparency, justice and fairness, and human oversight. Let's move to transparency. AI systems used in law should be explainable. All parties involved, from legal professionals to the public, should understand how AI reached its conclusions or recommendations or decisions. AI systems must be carefully evaluated to ensure that they don't perpetuate biases or exaggerate inequalities. This is particularly crucial in a field that seeks to uphold justice and equality before the law. No matter how advanced AI becomes, human judgment should remain central in the legal decision-making process. AI should serve as a tool to assist legal professionals, but not to replace them. In conclusion, the ethical use of AI is not just a technical issue, it's a legal and moral imperative. As artificial intelligence continues to evolve, we must remain vigilant in ensuring that it's used in ways that are fair, transparent, and accountable. I call upon all of you, my esteemed colleagues, students, and legal professionals, to commit these ethical principles. Let us lead by example, demonstrating that while we embrace innovation, we do so with a firm commitment to justice and human dignity. Thank you very much for your attention. If you have any questions regarding to my presentation, it's very short, but I think it was helpful for everyone. If you have any questions, we can discuss the ethical use of AI. For example, in Turkey, you might have some.
Thank you so much for your the excellent presentation, and you have already done a great job for the timing. I didn't have to worry about that at all. As you have already mentioned that who should be responsible, there are two important questions relating to regulations of AI. The first question is always whether or not we should be regulating the AI, and who should be responsible to regulate the AI. What are the stakeholders, the interested parties for the regulation of the AI? And the EU's AI, the Act, is a milestone the legislation, and which is already has been inspired and got the role model by many countries, including Turkey and Uzbekistan. And actually, this is not the first attempt to regulate the AI, but because of the whole economy and then international politics and then strong of the EU, many countries do the monitor of the AIs, the regulations. And there are always some ethical the concerns while taking advantage, utilizing of AI. As you have already mentioned, there are three important the principles coming from the EU Act, the countries has already been paying attention. Those principles are the fairness, transparency, and accountability. I do have a personally, I do have a question to you. Are there any legislative efforts in Uzbekistan to regulate the AI at all?
Okay. Currently, we don't have any regulation that regulates AI, the ethical use of AI especially. However, our government has recently enacted new presidential decree where we are going to establish, we are going to use AI we are going to actually to use AI systems in our government system, and we are just
Government
allocating some
authorities, right? Like
budgets.
right.
Government authorities are doing this. They are trying to allocate some budget to use AI. But the main problem lies here that even though we are allocating some budget to regulate AI or to create some AI systems in our government systems, the main problem lies that it's not we who are creating the AI. The creators of AI are in USA and a lot of tech giants. So therefore, we have to use their AI systems. And the problem will become that if we use it in our government system, how should we regulate our data retention policy? Like how should we regulate our data? For example, we might have some data that can be government secrets or trade secrets, but since we are not creating AI ourselves and we are using some APIs of that giant companies, who guarantees that they don't use our data against us or they don't monitor our data? That will be the main issue. I think it's the main issue in many countries, like when it comes to data protection. That's why I think our government should regulate the ethical guidelines of how to use AI ethically. For example, if we use it in our government system, how should be our responsibility? What kind of data should we input into the AI, or what kind of data we should not input? These ones have not been regulated yet, but I think some steps may be done so far, but we don't have any regulation currently. We have many questions that has not answered yet.
Thank you so much. And Mr. Temur Plato is going to be the next, like the presenter. He's gonna talk about the legal aspects of regulating crypto activities in Uzbekistan. He's also a young lecturer teaching at like the Tashkent State University of Law while doing his LLM at the same institution. You do have 15 minutes, Temur.
Assalamu alaikum. Greetings from Hospital Batarain in Tashkent. So, thank you for the honor to speak here with you among the professions of Turkish and Uzbek side. So, my name is Timur Bek, as mentioned, Dr. Samet. Recently, I'm back from States. I got there my LLM degree in information security law at Pennsylvania State University. I joined the cyber law department, Tashkent State University, under the supervising of Professor Gulyamov. So today I would like to address the pivotal role of government regulation and international cooperation in establishing security, transparency, and trust in the fintech sector, with a particular focus on Uzbekistan's legislation and its alignment with international standards. So, financial technologies are rapidly transforming the global economy, offering innovative solutions for payments, lending, and data management. However, this progress is accompanied by significant challenges, including cyber threats, risks of money laundering, data breach, and the lack of transparency in algorithmic processes. In this context, the role of state is crucial in ensuring a balance between innovation and the protection of users' rights. Uzbekistan, on its path toward digital transformation, is actively developing its legal framework to regulate the fintech industry. As mentioned, Professor Gulyamov, the Digital Uzbekistan 2030 strategy or initiative reflects the state's commitment to integrating into the global digital economy and fostering national fintech companies in line with international standards. So, one of the critical aspects of regulating is user data protection. Uzbekistan's law on personal data requires organizations to ensure the security of personal data processing, including financial transactions. This is a significant step in building a trustworthy environment for users. However, it must be complemented by strict enforcement mechanisms and accountability for data breaches. Western regulations such as GDPR demonstrate that the legislation must go beyond data protection to ensure users' rights to transparency and control over their data. And Uzbekistan is making initial strides in this direction, but achieving full compliance with international standards will require additional legal measures, as we know. So, equally important is the fight against money laundering and terrorist financing. Uzbekistan has incorporated FATF recommendations into its legislation by adopting the law of combating legalization of proceeds from crime and terrorism financing. This law obliges fintech companies to comply with KYC procedures, monitor suspicious activities, and report them to regulators. But, however, fintech companies in Uzbekistan face challenges in implementing these requirements. Investment in artificial intelligence technology is essential to automate transaction monitoring, enabling the effective identification of suspicious activities. International experience shows that integrating such technologies not only ensures AML compliance, but also enhances trust in financial institutions. As I mentioned above, transparency in online payments and mobile banking is another critical issue. Uzbekistan has made progress in improving transparency through the creation of a national digital payment system that allows users to track their transactions and understand their terms. However, users often face a lack of clarity about how algorithms such as those determining creditworthiness operate. Here, blockchain technology plays a vital role. Blockchain is a distributed ledger. According to Presidential Act number 3832, it allows every transaction to be recorded immutably. So this significantly enhances user trust as the data becomes accessible for verification and analysis. In Uzbekistan, blockchain technologies are already applied in the regulation of digital assets, opening new opportunities for fintech companies. Uzbekistan actively collaborates with international organizations such as FATF and the IMF to harmonize its regulations with international standards. This is particularly important given the growth of cross-border payments, which require aligned regulatory approach between countries. A notable example of successful collaboration is the World Bank's assistance in developing national security standards for digital financial operations in Uzbekistan. To make further progress, strengthening international cooperation through standards harmonization is essential. This will reduce barriers for national fintech companies seeking to enter global markets. For example, EU directives such as PSD2 could serve as a benchmark for developing open legislation and banking legislation in Uzbekistan. Despite the achievements above, Uzbekistan faces several challenges. First of all, its financial literacy among users remains low, increasing the risks of fraud. Next, the high cost of advanced technologies like blockchain and AI poses difficulties for small and medium-sized fintech companies. And finally, the diversity of international standards creates legal uncertainty for companies operating across multiple jurisdictions. Addressing these issues, I guess, will require developing user education programs, incentivizing state investment in fintech infrastructure, and strengthening international cooperation to unify standards in this field. So, as we saw above, the fintech industry in Uzbekistan stands at the threshold of significant transformation. Government regulation and international cooperation play a vital role in creating a transparent, secure, and trustworthy environment for users. Achieving these goals will require continued development of the legal framework, adoption of innovative technologies, and strengthening of international partnerships. These efforts will not only protect users, but also position Uzbekistan as a competitive participant in the global fintech ecosystem. And I'm done, and thank you for your attention. Please, if you have any concerns or questions, I am open.
Thank you so much, Temur, for your eye-opening presentation as well. This semester, actually, I have been teaching cryptocurrency and blockchain law. And if you are interested in, please feel free to come and to give a speech about maybe Uzbek experience, or to talk about a little bit more details for the crypto, like the currencies. As you have already mentioned that like the countries like Uzbekistan and Turkey has been interested in like to follow like the payment systems, because there are always some like the criminal activities behind what is going on. Although like the blockchain, like the system should be considered or must be considered one of the most like the safe like the systems as well, there are always some advantages and disadvantages. And how to regulate like the cryptocurrencies, especially relating to the taxations issues, is another important area. As you have already mentioned that it is a decentralized like the systems. That's why it is a little bit hard to talk about cryptocurrencies, I guess. That's why it is
Totally.
somehow complex issue, like to follow the whole payment process for the taxation. But income is always considered as income regardless where they are. If it is even if the whole income like the system might be like to consider as an illegal method, but governments are still motivated to charge the taxation against like the you name it companies, and like the people like utilizing taking advantage of like the whole cryptocurrency systems. Do you guys have any questions, comments relating to the Temur's like the presentation? Thank you. And we do have our final presenter, and her name is I'm sorry, his name is Nizamettin Kazimov. He's gonna talk about the role of legal tech. He's another young lecturer working at the cyber law department at Tashkent State University of Law. So you do also 15 minutes. Thank you.
Yeah. Assalamu alaikum, dear colleagues, ladies and gentlemen. I'm Nizamuddin Kazimov, a lecturer at Cyber Law Department here at Tashkent State University of Law. And today I would like to talk about modernizing legal practice and the role of legal tech in reshaping the law practice overall in the world. So let me start with a definition of legal tech. So basic definition of legal tech is just using technology in our legal service. So as a lawyers, we don't produce any goods. We are providing services. So using technology in our legal service is called legal tech. So with the rise of legal tech, the law practice is transforming, especially with the rise of AI. So basically, the academics, mostly Western academics, divide legal tech into three stages. So I guess we already passed the first stage, which was the basic usage of Word, Excel, Microsoft softwares, using a Zoom maybe online platforms. So currently we are on the second stage, which is the stage of using AI. And then the third stage, it would be much more difficult or much more yes opportunity. So in the third stage, I think it's gonna be use of machine learning with the rise of quantum computers, for example. It's gonna be on the one side, it would be challenging. On the other side, it gives much more opportunity if we use it in the right way. So transforming the legal industry gives to the law firms, first of all, time efficiency. So legal tech streamlines the process, automates the task, and reduces the need for manual work, allowing to our lawyers to focus on more high-value activities. It also improves the client service. Legal tech empowers the lawyers to provide better client service with improved communication, greater transparency, and more accessibility of the information. And third, it also enhances the legal practice. So legal tech tools offer new ways to analyze the data, conduct research, and manage legal matters, allowing lawyers to deliver more effective legal service. So streamlining the workflow with the practice management software, first is the case management. So practice management software helps lawyers organize and manage case efficiency, track deadline, and collaborate with the team members. The second is billing and invoicing. The streamline the billing process, sending invoices and the manage payment with ease, improving the client satisfaction and the financial management. And it also helps with the client communication. So it improves the client communication through secure messaging, document sharing, and online portals, offering a more convenient and responsible experience. So automating legal documentation and contract review. So legal tech tools automate the creation of legal documents, saving time, reduces errors, ensuring consistency and accuracy. The second is contract review. AI-powered tools can analyze the contract by themselves, identify the risks, and highlight the potential issues, improving contract quality and efficiency. And redline the version of control. Collaboration features allow for streamlined documents, editing, tracking changes, and managing reversion, simplifying the review process as well. So leveraging AI for legal research and analysis. So it increased efficiency. AI tool can quickly search through vast amount of legal data. As I said, saving a majority of time for our lawyers. It also improves accuracy and enhance the insights. So let me show what have done by the Uzbekistan government in the past few decades.
Nizamettin, we cannot see your, okay. It's uploading right now.
Just a moment, Dr. Samet. We're having technical difficulties. And by the way, thank you for the cup. This is my favorite one.
Professor Chelenk, you are the one bringing the mug to them, I guess, right?
No, I'm not. No, I'm
maybe
not.
This is yeah. You probably got the mug from our center. Sanat, are you there?
Assalamu alaikum, Professor
Sanat,
Samet.
Sanat is my favorite person, as usual. Keep going.
Let's see you. We are
Okay.
waiting for you.
All
When
right.
are you going to come?
Inshallah, I'll be coming to Tashkent in the middle of like the December, inshallah.
Okay.
We are gonna organize a good conference.
Okay. I will participate.
You will. Nizamettin, we can see your desktop right now. Please click the presentation or your PPT. Waiting you.
Yeah. Can you hear me now?
Yes, we can hear you.
Yeah. Let me show. So this is MyGo portal done by the government. So what it offers, so everybody in Uzbekistan, so every citizen
We can't see anything, by the way. We only see your desktop. There are like some files. TUSL, you name it, screenshot, some legal tech documents.
really?
Open the document, open the PPT.
Sorry for inconvenience. So I think I have part. Okay. How about now?
Your mouse is moving around, but it doesn't seem like you are opening anything at all.
We can't see any.
Do you see the MyGo's? No?
No. We see
Okay.
your AirDrop recent application.
Okay,
Yeah.
sorry.
You are using a
Sorry for
MacBook.
technical. Yeah, sorry for
Yeah,
technical
it's opening, I guess,
issues.
right now. There are some like the black like the screen on the shop. It's a black stage right now.
How about now?
Sorry, I guess no, we can't see anything.
Okay, let me explain. So
All
we
right,
have
we are listening to you.
over 200 services. So everybody can access in our country. Every citizen has access to MyGo US portal, which provides over 200 services, including the payments, like any documents, your obtaining a credit history, enrolling a child in preschool. So we offer over 200 services with the MyGo portal. And as well, we have a e-suit where you can download the previous cases reviewed by the courts, even regional courts. So currently, economic courts have reviewed over 800,000 cases and over 2 million cases reviewed by the civil court. So everybody has an access to download and review the cases. So it makes easy for our lawyers to review the cases, what happened, the case laws. So it really enhances and saves the time of our lawyers. So yeah, we are on our way to implement the AI currently, and we're with the help of our president Shavkat Mirziyoyev, was created a IT park here in Tashkent, where the IT guys working very hard there. So currently we are on our way to implement the AI. Yeah, that's my presentation. Thank you for listening. And by the way, sorry for technical issues. Yeah, if you have any questions, just feel free to ask.
Nizamettin, Thank you so much.
May I ask a question?
Yeah,
Yes,
sure.
Nizamet. I wonder, are all court decisions reviewed and published or some selected ones on this database?
How to select?
Selected, not all, I mean the court decisions
Mm-hmm.
or some court decisions only published. I wondered this.
All the court decisions. So if you
all the
see here, yeah,
understand all the
there
court
are,
decisions.
yeah, all the court decisions, except for those who are willing not to provide like their information, except
I
for
understand. Okay,
closed courts.
I understand. Okay, thank you very much.
Yeah.
Okay, friends, thank you so much for your awesome presentation. You have already talked about the legal tech, like the developments in Tashkent. For those who haven't been in cyber parks, like in Tashkent, it's a great the project. You all have to go and then to see what is going on. And we are perfectly done with today's the presentation. Professor Gulyamov and Ordine have already left because they got other the business meetings to participate in. We are gonna see each other for the next month, inshallah. Any questions, comments, Professor Chelenk? Do you want to give a quick closing speech?
Oh, thank you very much for all your effort in organizing. It was an amazing time to be together today and a very insightful presentation we had. And I hope maybe more new 10 roundable talks or more than 10 ones so we will have together. Wish the best for all the speakers and all listeners. Thank you very much.
All right, friends, we will see each other virtually next month at another roundtable talk event. Bye bye. Take care of yourself. Thank you.
Thank you.
İyi geceler.
İyi
Teşekkür.
geceler. Enjoy the rest of your night. İyi geceler. Bye.